576. Sherry Gail Duke, Castle Park Investments versus small child occupant, Eric Unknown, Cherie Valencia, and others. Who do I have here on behalf of Duke and Castle Park?
That would be me, Your Honor, Sherry Gail Duke.
Good morning.
Good morning.
Do I have anyone here on behalf of, let's go first with Cherie Valencia. Anyone here for Cherie Valencia?
Yes, I'm present.
Good morning. And then is there anyone here representing the occupants?
No, but I also have Eric on the phone listening, and he'll.
So Eric is here, Miss Valencia is here, but no one for the occupants. All right, that's fine. Ms. Duke, tell me why this eviction sought.
Okay. So I started on the property on September the 13th. Actually, I'm sorry, September the 15th. And we actually had a visit from our corporate office, and they saw the site of what 121 looked like. And we're also trying to build a tiny home community at that point in time. They did ask me to get with the occupants to clean up their site, which they had not at first. But so what had happened is that I had to send 2 notices of violations to their properties, that they had way too much stuff. There was bedroom furniture out in the back of the RV, and all of this is facing our road, so it was affecting our business, and we were losing revenue from our tiny home community. So at that point in time, when I sent them the notices, I never heard anything from them. And when I told them I was going to send them an eviction, that's when they came into the office, Miss Cherie, and then Eric came in as well to the office and was screaming and yelling at her. And then later came back and told me that's how he speaks with her. But I don't allow that kind of talk in my office. It's not professional. And it just didn't make me feel very safe. So
if I hear you correctly, then this is about a lease violation. They have too much trash at their property.
Yes, this is the lease violation. So
okay,
but
Miss Duke, Miss Duke,
you got to tell them that we were given permission. We got
sir,
Eric,
you're proving the plaintiff's case.
It's
what you just did is prove the plaintiff's case.
We'll have her turn to talk.
Miss Valencia?
Yes.
Not a good start for your side of the situation.
I apologize.
Like he literally just said, he came in and started yelling, and before I could ask her a question, he yelled out.
He was unaware of the rules, but I let him know.
I find it hard to believe that anyone doesn't know they should conduct themselves with decorum in a courtroom.
He didn't hear the part where we
How
were
old
gonna.
is he?
Yes.
Is he an adult? Is he over 18?
Yes, he is.
Then he should absolutely know to behave with more decorum in a courtroom. Anyone who's seen TV knows that that's how you behave. We'll return to the plaintiff's case. Miss Duke,
yes,
is there a written lease?
I was being heard.
Miss Valencia, you can actually mute yourself and avoid any further embarrassment. Miss Duke, is there a written lease?
No, there is not. What
Then
she actually had.
Miss Duke,
I'm sorry.
there's no written lease.
No.
Now, you said that you came into this sometime in September, so you are a new entry to this situation.
Yes, Your Honor.
To your knowledge, or the knowledge from the company you're representing, how long have the defendants been in possession of the unit? How long have they been tenants?
Let me look at that. They actually moved in on July 31st, 2025.
And if there's no written lease, how do I know what the terms and conditions are?
What they have is a site agreement. It just says what they're going to be paying. And they are actually parked in a platinum site. And of course, I was not here.
Miss Duke.
Yes.
You told me there's no written lease, but then you said they have a site agreement. What's a site agreement? Is that in writing?
That is in writing, and it just says what they're going to be paying.
Is it signed by the defendants?
It is signed by the defendant, but it's not signed by management previously.
What's the date that it was signed?
It was signed on actually, there is no date on here.
Does it have any terms and conditions? Because there's nothing that was submitted to the court. So I can't look at this magic document to know if it actually has any terms or conditions that they could have violated.
This was submitted to the court online.
Shay, do you see it? When was that
Electron-
submitted, Ms. Duke?
That was submitted on. Let me look at my paperwork. November the 5th, 2025.
I have the petition. It's just 2 pages.
That's correct, Your Honor.
Ms. Duke, is there a chance you could share your screen and show it to me? Do you have it
Sure.
online?
Put a note on there on 11-5 on the notes tab that it was filed without notice to vacate, military affidavit, and lease.
So nothing came in, Ms. Duke.
I'm sorry, Your Honor.
We have a note that it was filed without any additional paperwork. We just got a petition. No lease, no military affidavit, no notice to vacate, nothing.
Okay, so this is the first time I'm actually doing it online, so I know that's not an excuse. But I know that corporate does want them to move.
Well, I get that, but you don't have a lease. All right, let me ask another question. So there's no agreement to pay rent that I'm aware of here. Under the site agreement that you're looking at that is signed but not dated, is there an amount that's supposed to be paid?
It's actually supposed to be $875 because the site they're in.
That's not what I asked, Ms. Duke. What does the agreement that you signed say?
$699.
See what I'm saying? Don't misrepresent things.
Okay.
If what you signed that's not dated and you didn't provide me proof says $699, you need to go with $699.
Okay.
Okay. Now, is she renting a site or an RV?
She has an RV in the site.
But is she renting the RV or the site or both?
The site.
The site. And is this a place for manufactured homes?
No, it is not.
What day was the notice to vacate provided?
That was issued to them on October. The first one was on October the 9th. The second one was October the 20th.
And the one on October 9, how was it delivered?
It was actually hand delivered, and then I also sent it via email.
The one that was hand delivered, what were the terms and conditions on it?
It was actually in an envelope. I knocked on the door and nobody answered.
No, but what does it say? Because you didn't send them a copy. I don't know. So what
Yeah.
does the notice to vacate tell them?
It tells them, you are hereby required to vacate the premises on 25928 Haney Flat Road, Spicewood, within 72 hours of the notice. You were served this notice on 10/9. 72 hours after the date would be 10/12/2025. If you have not vacated the property by 10/12/2025, the police will be called to escort you off the property.
All right. Then how about the one on the 20th? How was that delivered?
That one was delivered on the 20th as well. Yes, Your Honor. And it stated the same thing.
How was it delivered?
It was hand delivered and then via email.
Another 72 hours?
Yes, Your Honor.
All right. Do you have any evidence to support the lease violations?
We actually do because their site was a mess. I actually have pictures.
That's what I'm asking, Ms. Duke. Can you share those photos with the court?
I did not. They were actually on my phone, so I did not share those.
Do you have a witness who can testify as to the state of the property?
Yes, my assistant manager.
Fantastic.
Jason.
Where are they?
Would you like for me to call him in?
Yes, Ms. Duke. You have to prove the case.
Okay.
All right.
Okay. We are asking him to come in.
Ms. Duke, while he's coming in, take a look at the site agreement. Other than amount for payment, is there any details or conditions on it?
It just says the site excuse me, the site agreement is made between Spicewood RV Resort, referred to as herein as the owner, and the individual referred to as herein as guest. Guest agreed to all terms and conditions of the license agreement and additionally are bonded by all site guidelines incorporated as Addendum A.
Is there an addendum A attached to it?
No, ma'am, it's not.
And that doesn't do you any good. Ms. Duke, I'm afraid that you're not meeting the burden that you need. In order to show me that she's violated a lease, there needs to be a lease and there need to be conditions on it. If what you have is simply a site agreement that, per your information, isn't signed and isn't dated and has no addendum to it, you're not going to meet the burden of a violation, because even if you came in and showed me photos of a bunch of trash, what tells me that that's not allowable under the agreement that you signed, even assuming I agreed that thing was signed.
I
Right?
understand.
And for Mr. Eric Unknown having a very, aggressive way of handling himself, I'll grant you, that's not a great way to behave, certainly not in court, but that is not a violation of a lease if one doesn't exist.
Okay.
All right?
And Jason is coming in now, Your Honor.
I look at your petition, you only sought a violation for lease violations, nothing about unpaid rent. I take that to mean that the defendants have paid their rent in full.
No, I did not collect rent on them at all. I'm doing exactly what corporate asked me to do, and they just wanted them to leave. We do not want to even collect any money.
All right. Well, unfortunately, Ms. Duke, with that information, I don't find that the landlord is meeting their burden to show a lease violation. Certainly, you can appeal my decision, right? This is the example where the landlord might want to appeal.
Okay.
And you can move forward that way. You can appeal. You can start the process over by alleging a different type of lease violation or the same thing. You can do as you like. Certainly,
Okay.
you can talk to an attorney or to corporate, and they might have a different idea about what they'd like to do. But today,
Okay.
it's going to be a judgment for the defendant, and it's going to be for a lack of evidence.
Okay.
Certainly, you both can appeal. I would put the appeal bond at
They want to
$6.99.
know
That's
what
equal to one of the site
the
amounts.
judge would like to know what their site looked like.
It was a mess. They had,
We're not taking any more testimony.
Okay.
Here's the thing. When you file the eviction, it is always best to file the necessary documents, the lease, a ledger, a notice to vacate. We don't have any of those things, so I can't review them. And what I was hearing today in the testimony from Ms. Duke is that the site agreement does not have an addendum. It doesn't specify any terms and conditions. It only specifies an amount of money. Nothing in the petition. In fact, the petition explicitly states that y'all are not seeking anything for unpaid rent. So if it's
Okay.
just a lease violation, I don't find evidence to support that.
Okay.
Absolutely still have options. Ms. Valencia, they can still do other things. So I would encourage all parties to maybe communicate with each other about a resolution. All right. Ms. Duke, do you have any questions?
No, I do not.
All right. Ms. Valencia, do you have any questions?
Yes, actually. I would like to know where I can file a claim to countersue.
There's no counterclaim in an eviction. That's
Well,
not
the thing
allowed
is,
under law.
ever since Miss Sherry Duke came into the office as office manager, we're an interracial couple.
Ms.
and-
Valencia, please contact legal aid if you think you have a claim
Yes,
against your
and
landlord.
I have.
There's
I've
no such thing
contacted.
as a counterclaim in an
Yes,
eviction.
ma'am.
Okay.
I've
All right.
contacted legal aid.
Fantastic. Good luck, everyone. All parties are excused today. Thank you.
Thank you.
Thank you.
All right. Appreciate. Thank you for checking. Sometimes it gets lost in it, but no, nothing came in. All right. Next, we're going to be with 251577. That is Reynaldo Lopez, Nora Lopez versus Antonio Mendieta Jr. and Lisa Ross. So who do I have here on behalf of our plaintiff Lopez and Lopez? Anyone? Do we have anyone here for cause 251577, Reynaldo Lopez and Nora Lopez versus Antonio Mendieta Jr. and Lisa Ross?
This is Mr. Ronaldo Lopez.
Oh, good morning. Thank you. Mr. Lopez. All right. Do I have someone here on behalf of Antonio Mendieta Jr.?
Yes, ma'am, I'm here.
Are y'all in the same
I'm
county?
here too.
Oh my God.
This is Nora Lopez.
Hello, hello,
Okay.
ma'am.
Okay, everyone's yelling. All right, I got.
Can you hear me?
Yes, I did, Miss Lopez. I can hear you.
Okay. All
All
right.
right.
I'm the one that filed the eviction notice. My brother's a homeowner. I'm the tenant.
Mr. Mendieta,
Yes,
is the gentleman next to you? Who is that?
he's a homeowner.
That's Mr.
What
Lopez.
do you say, me?
Yes, ma'am. He's a homeowner, and the person speaking, Nora, she's just a tenant.
He's not
No,
touching.
I am the tenant. What do you mean I'm just a tenant?
Yeah, that.
You're just a squatter.
she's-
Don't tell me out there, 'cause I don't see myself on the.
Do y'all all live in the same household? Is that why I'm getting?
Yes.
That's
We
where the
do.
confusing thing is.
Do you see
You see
them?
why the judge was confused because the plaintiff and the defendant are in the same camera together. That's why I was lost. Okay, now who is this person?
Okay, I don't see you.
Who is that woman, Mr. Mendieta?
That's the woman that filed the eviction,
Is
not
that
the
Miss
not the
Lopez?
owner. That's Miss Lopez. She's the one who filed the eviction, but she's not the owner.
Can you hear me?
Yes, I can, Miss Lopez.
I don't see you.
That's because you're not using your camera. You're just using the phone. If you've got to be looking on Zoom. Oh, okay.
Ma'am, she's not.
Okay, well, I don't know how to do it.
Here's my
I don't know how to
confusion.
do it. They know how to do it. They
Miss
think they got
Lopez?
everything going on over there.
Miss Lopez, if you just want to go stand next to your brother and see on camera, I can do the whole thing that way. You don't have to.
Okay.
But
I
then
don't want to be standing by them. I
All
don't want to be out there with them.
right, then go
I
back
don't want
in
to
the
be
house.
by them.
Go back in the house. because
Okay, I'm in the
you're
house.
close
I'm
to
in
them,
my
it starts
room.
to echo. Go, that's bad.
I'm staying away from them like I'm supposed to. They're not staying away from me like they're supposed to.
Okay.
He's already put me in jail twice. He assaulted me
Lopez?
numerous times, verbally
Miss
assaulted
Lopez?
me. He's
Miss Lopez, I'm afraid we've had to mute you. I want to give you some information and I want to take your information and Mr. Lopez's as well. All right? Mr. Lopez,
Yes.
let's begin with you.
Okay, ma'am.
Did you file the petition for eviction?
Did I file for it?
Correct.
No.
You did not file the petition.
My sister did.
Okay.
And my sister is not a tenant. She just lives in my house.
Mr. Lopez, you're the titled owner of the home
Yes.
and you did not file to evict anyone. Okay. Miss Lopez, I'm going to unmute you now. On your phone, if you'll press *6, then I'll be able to hear you. Mr. Lopez, while we're getting your sister to unmute, does your sister have any ownership interest? Are you Miss Lopez?
All right.
Good morning, Miss Lopez. All right.
Good morning.
Are you an owner of the property?
No, my brother is. I've been living here since 2001.
Okay, Miss
It's my brother.
Lopez, I appreciate that. Your brother, who does own the property, says that he does not want to evict anyone.
No, the thing is that I picked up assault charges on them. Actually, he assaulted me, and I went to jail. When I got out of jail, I went to the hospital for he stomped on my toes, and they were filming it, and I pushed him out the way, and then he stomped on him again. He broke my toes. I got hospital records of me going to the hospital both the times that he tried to say I assaulted him. He bit his lip and rubbed blood on his face. And then he's been breaking into the house. He's been stealing all kinds of stuff. I mean, he just needs to go. I mean, he don't pay rent. It's been 7 months. He ain't paying a penny.
I appreciate that, Miss Lopez.
He got his ladder over there where
Okay.
he jumps over the fence and gets in the house. And my brother lets him get away with whatever he wants to do. And that's
Sounds
not
like you might want to move yourself, but your brother.
But I don't gotta move right now. I don't have to move because this didn't start until they
Mr.
moved
Lopez,
in.
we're going to non-suit the case because you've told me you don't wish to proceed with an eviction. In fact, you didn't even file the lawsuit, correct?
Oh, he's saying thank you. So you're gonna continue to shoot the finger at me and call me
Case
bitch?
dismissed by the plaintiff. All parties are excused. Thank you. Have a good day.
The judge and the lawyer told me to file an eviction.
Miss Lopez, please contact legal aid about your rights as a tenant in your brother's
Yeah,
property.
I did.
Okay.
And he's already
Your
assaulted
brother-
me. I got adult protective
Mr.
services are involved.
Lopez, Mr. Mendieta, you're all excused. Miss Lopez, this case is being dismissed. The owner of the property has indicated that he did not file the
Case is being
petition.
dismissed?
and
What
he
are you
does not
talking
want to
about?
pursue.
So he can continue to
Thank
assault
you, Your
me?
Honor.
Thank you. All parties are excused.
Thank you.
All right, now we're going to turn to a little bit different matter this morning. We have a repair and remedy case, and that is going to be for cause CV 25003255, Brenlin Curry versus Harris-Wesley. Do I have someone on behalf of Brenlin Curry?
Yes.
Good morning.
Good
Do I have
morning.
someone here on behalf of Harris-Wesley?
Yes, ma'am. I am Amy Adams.
Morning, Ms. Adams. And are you management, owner, counsel?
Property management.
right, Ms. Curry, what type of repair are you seeking?
Yes, I'm seeking the court to order a complete sanitation and remediation of our home, which is including the kitchen, specifically behind the oven, dishwasher, and fridge, and all contaminated attic space, as there is an active rodent infestation.
All right. Ms. Adams, as the defendant, you can make an opening statement, or you can wait until I've heard everything from the plaintiff. What would you like to do?
I'm happy to wait until we've heard everything.
All right, Ms. Curry, when did you move into this unit? Let me ask you first question. Is it an apartment or is it a single family home?
Single
Motorhome
family
kind of. I'm sorry, Ms. Curry?
It's a single family home.
Single family home. How long have you been a tenant there?
Since October 13th.
Of this year?
Correct.
All right, how long is your lease?
For 2 years, 24 months.
Prior to move-in, did you have a chance to inspect the property?
Yes.
Did you notice anything when you inspected it?
No.
After moving in, how soon afterward did you begin to experience the problem?
So we got the keys on the 13th. We didn't have everything moved in until the 17th. On the 13th, when we were looking through cabinets, we noticed that there were urine and feces, which I sent to the landlord. You can see that in Exhibit B1. I sent a video and an email letting them know.
Let's take a look then. Is that stuff you submitted with the court?
Yes.
Ooh, okay, I see lots. Is there actually a video?
Yes. So in B1 is the email, and the attachment then is let me see.
And I was gonna say, Ms. Curry,
October-
one of your exhibits didn't come through. I don't know if you got my email this morning. I think,
yeah.
okay.
But October 13th droppings is in the first evidence packet. It is a .mov. I'm not sure if that.
Yeah, so we have sometimes trouble with things like that. Let me ask you this. Do you have it on your device? Could you just, if I gave you screen share, could you play it for me?
Yes.
Let's do that. I'm going to give you some caution. We can allow you some screen share. Just please, if you've never screen shared with Zoom, any tabs you have open
Yes.
might accidentally come through. And so to the extent that you're, just have open that particular movie tab when you share it. Okay.
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 Are you able to see?
Mm-hmm. Okay. So I see it looks like saltillo tile.
That's on the kitchen floor. It's underneath the dishwasher. And then I will open the cabinets in this video as well.
Oh, no, that might have been a version to run stuff, but yeah, you're right. That's definitely droppings. Ms. Adams, any objection to that being a video taken by the plaintiff in their apartment or the home the first day?
No, ma'am. She sent that to me 7 p.m. on the day she got her keys.
All right. Ms. Curry, after you made the video, you submitted the information to the landlord. Did they come out and make any attempts to repair it?
They sent a maintenance person to patch holes.
And to clean the area.
They didn't clean the area.
We'll come to it. Right. Okay, Ms. Curry, you said this landlord sent out maintenance to patch the holes?
Correct.
When was that?
That was the next day.
Very next day.
On the 14th.
Yes.
All right, Ms. Adams, you don't have to do anything. You got to be quiet. Let her do it. I appreciate it, but we'll give you a chance. Okay, so now it's the 14th. They come out, they patch the holes. What next?
On the 14th, I said, thank you for sending a maintenance team. Would you please arrange for a licensed exterminator to inspect the property? We haven't been able to check the attic yet, and we're concerned that there may still be some live rodents as we can hear them. Since we have a baby and we're moving in on Friday, we want to make sure the space is fully safe and sanitary before then. Thank you for understanding.
Could you hear something moving around?
Yes. And we've seen them.
At that point, though, you had.
Correct.
Okay, so now it's the 14th. You've asked them to give you a full exterminator because you said you're hearing sounds in the attic. What the landlord responds?
They didn't. And so on the 16th, I had to follow up saying, hello, I want to follow up regarding the condition
Ms.
of the
Curry,
home.
Ms. Curry, did they say no or did they do nothing?
They did nothing.
That's a different thing. Landlord didn't respond. So you followed up with them on the 16th.
Yes.
Okay. So landlord didn't respond. 15th, nothing happens. Now we're on the 16th. You send said, hey, I'm following up. I want you to give me an extermination.
Correct.
In the days on the 15th and the 16th, had you done any inspecting? Had you looked around? Did you notice anything?
Yes, we went up into the attic and we noticed that there are a lot of droppings.
What day did you look in the attic?
On the same day I sent, so the 16th.
So you looked in the attic and then you sent a follow-up.
Correct.
Okay. Did you take any photos in the attic or any video?
I have those, but I did not send those.
Okay. What did you discover in the attic?
I noticed urine and droppings.
Did you actually spot that day any live animals?
No.
Okay. What was the response to your request?
On
Did they
Friday,
respond?
yes, on Friday they responded
What day
saying
is
they
that?
hadn't heard back from pest control yet.
Ms. Curry, what day was that Friday?
October 17th of 2025.
Okay, so the following day, landlord responds, and their response was?
They will get pest control out.
Said they'd send pest control. All right.
And then in regards to the state of the cleanliness of the home, they decided to give us a credit to our rent.
How much was that?
$300.
All right. What happens next?
On October 17th, my husband then emails, thank you for the credit, but I don't know if you saw in our last email that none of our windows are locking. So what can we do about that? Which they then said that they'll have somebody come out and look at.
When did you discover that the windows wouldn't lock?
On the day of move-in, on the 17th.
What was the landlord's response to the fact that the windows wouldn't lock?
That it was operator error.
Did you try again?
Yes, and I even sent videos.
Have the windows been repaired or fixed?
There's a manual lock that I have to add to the top to get them to lock.
When you say the windows won't lock, are they like the pull down windows that have little latches on them? It's this
You
way.
slide this way.
And then there's the latch like that on the center.
Nope, it's you have to push it and push it all the way in.
Can you actually show me a photo or demonstrate? Because I'm having.
Here's a video.
If that's one you already submitted, I can pull it up then. Right? I don't know about the video. If you've got it, that might be easier.
Yes, I do.
Okay. Let's take a look. Real quick, Miss Curry, what window is this?
The one right behind me.
Okay, so that's that window behind you?
Mm-hmm.
All right, you'll start the video over then.
So that's the lock. So you can't push it all the way so that it locks. And that is the lock that we have on every window.
What's on the other side of that you're opening?
There's a
Is it-
screen.
Oh, that's just the screen? And so the landlord told you it was user error?
Correct. And that Fernie, their maintenance service technician, had come out and shown us how to use the windows properly.
Had someone demonstrated those to you?
Yes.
And did they work when they were demonstrated?
No.
Do any of the windows lock right now?
Some of them do.
With that same kind of lock?
Correct.
So sometimes it does work on the other windows, and on those that it's working, but on this one it's broken.
Correct.
All right. So you tell them that the windows aren't locking. They tell you it's a user error. That's on the 17th. What happens next?
Yes. Then as we go on the 16th, when we asked about the windows, we also didn't have our utilities set up yet. The Texas gas service was only able to come out on the 20th. And when they came out, they red tagged our stove and oven. So in Exhibit B2, you can see that they exposed the gas line, said it was a serious fire hazard, and ordered it to shut off. So this left us with no way to cook and no hot water. So for the first 12 days being in this home, we had to travel to our family's house every day to bathe my 1-year-old daughter.
Okay, Ms. Curry.
Cook here.
The 17th, you find that you're trying to move in, right? You got the keys on the 13th. You inspected. You found the drop-ins. You said, "Hey, come and clean this thing." They said, "Sure, we'll send someone out." The 16th, you follow up. "Hey, we looked in the attic. It's worse than we thought." 17th, they say, "Got it. We'll send out pest control. Sorry, it wasn't clean. Here's $300. You say, "Great. What about the windows not locking?" And they said, "That's your error. We showed you how to use them."
Correct.
3 days pass with nothing else taking place.
Correct.
Okay, and then on the 20th, you're going to get your gas installed because you need gas in it. They come out. Texas Gas says, "We can't hook it up. You've got a big problem here."
Yep.
Okay. Did you notify the landlord about that?
Yes.
When?
On the 23rd.
How did you notify the landlord?
Through email.
What was their response?
Do you not want to live at 1800 anymore? Are you trying to end your lease? There is no reason to speak to us this way, as we do not respond to threats in this kind of tone. We are two busy working moms and get maintenance requests all day, every day. For anything that is a non-emergency, it seems you have forgotten how to submit maintenance requests. I could go
Very
on.
specific response. Did they address the fact that the gas couldn't be turned on?
They said, "Why is Texas Gas Service in the home? If there's an issue, again, contact us."
But they did not make any attempt to repair the fact that you couldn't get the gas hooked up?
Not yet.
All right, so the 23rd, you get not helpful answer from the landlord. What happens on the 24th? Or did you do anything else on the 23rd?
No, we just went and stayed with family.
All right.
And we get a text message on the 24th with a less than an hour notice saying that a handyman named Ben was going to come to the property.
What was the handyman going to do?
He was going to attempt to fix the gas line and check all the other broken appliances that I had noted in my email to her on the 23rd.
Ms. Curry, is that what they told you or what you're assuming was going to happen?
No, that is on the text message.
Okay. And do you know if someone came out on the 24th?
Yes. Ben, I said he could work on the dishwasher and the washing machine, but that a licensed plumber needed to be the one to fix the open gas line.
He worked on the dishwasher and you said the washing machine?
Correct. Neither were working when we moved in.
Are you paying anything for those appliances, or are they just included in on-site?
They were included.
Yeah, okay. But he wasn't licensed, so you said don't touch the gas?
Correct. And they had a licensed plumber come out that day.
So they did send someone who could actually do it the same day? Okay. What time does the plumber show up?
I have his work order that says 11:15.
All right. Do you know if the plumber repaired the gas line?
To the best of my knowledge, yes.
After that, were you able to get the gas service hooked up?
Yes.
When was that done?
That was done on the 25th.
So the following day. Okay. All right. So 24th, they come out, they fix the gas line. 25th, you get the gas hooked up. What happens next?
Then I had also sent in a request for an inspector to come out to the home. So City of Austin had a code enforcer come out and inspect the property.
On what
And
day?
we sent a notice to the landlord in Houston
What day was the inspector? Did they come out?
on the 24th.
So the same day that the plumber was there.
Correct.
So let's go back. So on the 24th, city code inspector comes out. Did they discover any violations?
Yes. Live infestation within the living area, which is in the kitchen. They were not allowed to go into the attic as there's a policy against ladders. But then they also noted structural damages as well.
To what?
The windows, flooring, doors, entry points outside the home.
Did you provide a copy of that to the court? Is that one of the exhibits?
Yes, it is. It is exhibit E.
Those aren't actually exhibits. That's just telling me what it is.
There's a violation report, a copy of what was posted to the outside of our home.
Jay, do you see it? Because I'm looking at the combined exhibits from the plaintiff, and that's not it. And all the ones that are separately labeled started in.
It was in, right? Wasn't it in?
I'm talking about exhibit E.
Yeah.
Oh, E.
See, I don't see anything. I see 42 pages that is a chronological accounting, but there's no exhibits in that. It says it's exhibits, but it is not. It is just the petition. And then the exhibits that I've got are K, M, N1, N2, O1, O2, and P.
Those were
Yeah,
submitted.
that'll work. Thank you. If you can zoom in and let me actually just read that. Maybe just press Control plus. That might do the whole thing for us.
Give me 1 second. I can zoom in.
Okay, thank you.
Sure.
Okay, October 24th, Harris-Wesley, Cannonwood Lane. City of Austin investigated the property. Violations were found that require immediate attention. Description of the clause below. After receipt of this notice and until compliance is attained, the City of Austin prohibits the sale, lease, or transfer unless you provide the buyer, the lessee, or other a notice of this violation and the name and address of the buyer, lessee, or others to the code official. All right, what's the next page? Okay. The items below are violations of the city code and require immediate attention. If they're not brought into compliance within the timeframes listed, enforcement may be taken. Timeframes start from the date of the notice, so as of the 24th. Okay. Loose window glazing in the living room window, seal and secure it. Infestation. All structures to be kept free from insect and rodent infestation. All structures in which they are found should be exterminated by an approved process. You get 30 days to bring that into compliance. So we get 30 days to fix the window, 30 days to take care of the mice droppings. Exterior doors, operator systems, and hardware to be in condition. Locks shall be tightly secure. Locks on means of egress doors shall be in accordance. Large gap on the right side of the patio door that's missing a trim piece. 30 days to fix the trim. All right, so it is window seal, mice droppings. I don't know if it's mice, it just says droppings. Oh, it says mice droppings, there it is. And then patio door trim. You get 30 days. All right. Thank you, Ms. Curry. Ms. Adams, any objection to that being a letter from the City of Austin to the landlord?
No, ma'am.
Okay. Ms. Curry, to your knowledge, were those items repaired or corrected within 30 days?
They fixed some.
All right, because it hasn't yet been 30 days since that notice happened, right? Today is the 20th. What has been fixed?
They did the trim to the patio door.
How about the window seal?
Nothing.
Your Honor, my invoice from my vendor shows that he did fix some window glazing.
All right, we'll take a look at it, Ms. Adams.
Okay.
I'm asking her to her knowledge. She says no, right? All right, so no window fix. How about the mice droppings?
We still hear activity, and I also had 2 independent inspectors of my own come out, and they reported a lot of activity.
When was that?
Let me look. I had a pest control come out on November 12th. And I gave this to you as well, and you can see on page 3 all of the attic contamination that still remains, as well as unsecured rodenticide as their means of trapping and exclusion.
Right. I see one from the 17th, and you said there was another one. The stair clean estimate. I see the 17th.
And both of these vendors came out after Miss Adams had their maintenance person spray bleach and do that in the attic. On the 7th, she came over and saw for herself that feces and debris still remain, but have told us that she can verify that the air we're breathing is perfectly safe and there's no harm to our family in keeping feces and contamination in the kitchen and in the attic.
Is this the letter that you received, or the kind of the outline that you got after the inspector, the private inspector, Absolute Pest Management, came out November 12th?
Yes.
Okay, I see at the
But he'd
top.
never seen people leave rodenticide open in an attic, and that is a biohazard to humans.
Ms. Curry, I'm just going to read it because that's what's going to be the best proof. Let me see what it says. So I zoomed in, Absolute Pest Control, Friendly Curry, 1800 Cottonwood Lane. Everyone agree that's the address we're at?
Cannonwood, yes.
Okay. Today I inspect the property for attic remediation due to rodent activity. Customers or tenant that moved in the past month or so noticed activity when moving in, reported feces and urine. Landlord hired another company to resolve the issue and asked tenants to get quotes for attic remediation as the customer is concerned about their child's health. In inspection, I found an unsecured rodenticide placed in the attic. It's unclear if it was put there by the pest control, addressing it, or a maintenance staff. Rodenticides must always be in a secured station for safety and are generally not recommended for interior use, as it increases the chance the rodent will die. Some are inaccessible for removal. I found both roof rat and squirrel tracks on the ductwork, as well as feces in the attic. I don't know if the pest control company is still working to control it, as I found little to no traps in the attic, or if they're relying on the rodenticides. There are exterior bait stations around the home. The level of rodent feces is not extreme, but it is consistent throughout the attic space. I will run numbers and submit a restoration bid. And did he give you a restoration bid?
No, Steri Clean did.
Okay.
Which is exhibit N1 and N2, and they
there.
did.
I'm just first one at a time. Got to go one. I got to look at the whole complete thing. So this is the letter you got from someone called Absolute Pest Management. They said they would give you a cure method. I'm just asking if you got one. The answer is no. All right, and then here's the photos that they took that went along with the report that day. So I can see it. All right. Feces. It says there's tracks on that ductwork, leaf litter and debris, along with the poop. Squirrel tracks on the ductwork. Oh, you got a little bit of both in there. Yeah, I see that. You can see where they're running through the dust. All right. Ms. Adams, any objection to this being a copy of a report that she had
ma'am.
from Absolute Pest Management?
No, ma'am.
Okay. And then you said you got another one, and that one is Steri Clean. This one is from the 17th. So, Ms. Curry, you got a second company come out, and this is who actually cleaned the property?
They have not cleaned yet.
Okay. They came out and gave you something. They said, this is an estimate for removing the insulation, cleaning and disinfection, any required extension. Rodent droppings and nesting can carry diseases. Got it.
And they gave us 2 separate. So there's one with the full removal of insulation and one where it's just the labor of cleaning up the feces and the urine. And although it's not written in this report, he gave me a quote of, if my dog pooped on your floor and I sprayed it with bleach but left it, it's still poop.
I don't know what that's supposed to mean. All right. So this one is significantly shorter, $12.99 versus $10,000. Right. This one is $10,214. This one, which doesn't touch the insulation at all, is $12.99. So two estimates.
It's the removal of the insulation and contamination, just not replacing it.
Okay. All right. Ms. Adams, any objection that these are copies of estimates she obtained from a company called Stericlean?
No, ma'am.
All right. Ms. Curry, in the interim here, since you had the code inspection, you said that the landlord did respond, that they came out and they fixed the trim on the door. Have they given you indication what they're going to do about the windows?
No,
How about on the mice droppings?
no. Other than emails where they've told us that we can leave our lease, they've offered that multiple times.
All right, so they've also let you to break the lease? Or rather, they've offered to terminate the lease because they don't want to, what you're saying is it's not a safe sanitary condition, and therefore, rather than fix it, they'd say just leave.
Correct.
And you don't want to do that.
No,
Okay. What is it that you do want, Ms. Curry?
I would like court-ordered remediation and sanitation of the home.
All right, Ms. Adams, what information would you share to further illustrate the situation for me?
Yes. Okay. I think going through the timeline is helpful that I attach because it does show a very thorough and robust response to the rodent issue. Unfortunately, there's just not an overnight solution to rodents, but we have had Oliver Pest Control engaged since before October 17th. On that date, I told Brenlin that I had already called Oliver Pest Control. They had her contact information and would reach out to her to begin service. Immediately, October 17th, my tech with Oliver said, I'm here, I'm doing, getting this all started, but there's some points on the exterior you could close up that would help. I had Mr. Barcenas there the next day, which was a Saturday, working on the exterior, closing up any holes. Fernie was there, Mr. Renteria was there October 14th. He cleaned up any rodent droppings under the sink area, and he filled in some holes with steel wool, caulking, anything that he could do that day on such quick response time. Mr. Barcenas. October 21st, the tenant, did send me an email requesting $7,000 worth of landscaping. I have put that in evidence for you to review. It wasn't from a company, she just drew it up. October 23rd, I received an email that Ms. Curry had made a report with COA code enforcement, as well as an email from Ms. Curry with the first mention of appliances not working. So although she did get keys on the 13th, we didn't know about appliances until the 23rd. I think it's worth noting that per her lease, the washer and dryer are not to be repaired by the landlord, but we absolutely did repair both. Luckily, the dryer just needed a breaker thrown, I believe. The washing machine needed a part. We had an appliance company that we love, ABA Appliance, out, take a look at it, troubleshoot it, order the part, and install. Of course, that all didn't happen in one day, but it did happen. I think if you look at the timeline, you'll see the amount of times that Oliver Pest Control has been there, setting traps, setting bait boxes, checking boxes, moving boxes again. I even approved a $500 bid with Oliver Pest Control on, I believe, October 26th to do $550 worth of filling in some other things they found on the exterior. Part of the home is, the original part of the home is on a slab, but there's an addition that's pier and beam. And he did $500 worth of filling some more holes than outside of what we had already done. They've just been on site, more than 10, 12 times. AVA repaired the washing machine on November 3rd. Are you looking at the timeline?
Yeah, I'm walking through it here. As
Okay.
You're giving me stuff, and I'm kind of looking through what you've given me here.
No, I see that, yeah.
All right, Ms. Adams, do you recognize this? This appears to be an invoice dated November 14th.
Yes,
from
ma'am.
Oliver Termite and Pest Control.
Yes, ma'am.
Okay. And the service information is for 1800 Cannonwood Lane.
Yes.
That's, Ms. Curry, that's the address you reside at?
Yes.
All right, so I can see this one. This is rodent follow-up, invoice number scheduled 11/13 for the 14th. And this is November. So move-in occurred or keys were given on the 13th, and this is essentially 1 month later. All right,
Yeah.
but I can see that it's an invoice and it highlights things going backward. Because it's 2 pages. So when I go back this way historically, I can see, well, yeah, this is an order. It goes this way. So
Right.
the first one is October 27th. So that's 14 days after keys were given to the plaintiff. And it is for sealing holes behind the stove. And
Yes, Your Honor, but I think you'll see there were visits noted before then. If you go to maybe page 6, just ahead of this one. Yes, 10/17, 10/20, yes.
all right. Placed rat trap in the attic, followed up Monday to check for activity, add traps if necessary, took pictures and spoke to Amy as she needs to repair the soffit. Also is pier and beam on the add-on, so we can't warranty any kind of seal. We'll start making a monthly bait program for 120. Trap not set off in the attics. They went back and they checked on it 6 days later. Placed a bait in the attic as well as 4 bait stations around the perimeter. Follow up in 2 weeks, which goes along with what we are seeing. All right. Come back the 24th. So this is the next day. Tenant said she saw 2 rats in the kitchen while we were in there, or while they were there. Plumbers were out cutting into the wall and adjusting the line, so I couldn't seal it up. We will have to reassess it on Monday when we come back. Placed 4 traps under the sink. All right. This is more. That stops the 24th, and then it goes over. Same company. 27th. Technician sealed the holes behind the staff. Follow up Wednesday. No activity on the kitchen trap since it was sealed up. Put 2 traps in the attic. No activity on the traps. Removed the traps. Trapping complete. So this is the 3rd. 2 glue boards on the sink. Follow up in a few days. Maintenance sealed holes behind the dishwasher this time. Bait box was emptied by the crawl space. There are areas to be sealed under the crawl space at the foundation. Sealing these and placing traps is the best defense against rodent. If I read this correct, if I'm reading this as it's written, twice they put traps in the attic, and neither time the traps got set off. Because here they put them on the 17th, placed the trap. On the 23rd, they said it's not there. We put up bait stations instead. Follow up in 2 weeks. Would have been around the 7th or so of November. I get in here. No activity on the traps, so they took them out. Placed 2 glue boards. Bait box is empty. Sealing of the spaces. On this first one, pier and beam on the add-on, so we can't warranty any kind of seal. We'll start a monthly bait program. Okay.
And I approved a 6-month program initially, just right off the bat on the 17th. I said, let's set it up on a 6-month service because I know it can be a process with pest control, especially in an older home.
All right. And I can see that just explains why over here, now they're going back to, all right, now we do need to seal it up since the mitigation isn't doing it. And y'all said, all right, did y'all approve to have the seal happen?
We did. It happened the very next day.
Okay. Found what appeared to be entry points where the brick skirting met the side at the back of the house, which is the pier and beam. Sealed all the areas around the brick. Okay, here's the sealing getting done. As rats are commercial, meaning the feed off the garbage of man, there will always be in areas where people live. Not a one and done. This is just them trying to inform the court in advance of stuff. Cool.
And there are photos of that seal work if you want to see it. It's just a bunch of black foam, but I did include
Did you
those.
spray foam in?
Yeah, it's like that ugly black foam. It's not pretty, but it works.
2 traps under the house were set off, and peanut butter is gone. Possibly it's a squirrel. Well, that's what the city inspector said. They saw a squirrel, or maybe it was the city, maybe it was one of the others, not the other companies that came out. Placed a squirrel cage under the house. Follow up on Monday. Also, bait box in the backyard were thrown around, so possibly a raccoon's been making noise. All right. So you have Oliver Termite and Pest Control. Did you have any other services, Miss Adams, that came out?
For pest control or other stuff?
For pest control. Let's focus on pest control right
For
now.
pest control, I mean, it would have just been my guys doing exterior siding work. It would have been Mr. Renteria closing up additional holes under the sink. There was a kind of a gap around the dishwasher. He had to pull the dishwasher, close that up, and reinstall the dishwasher.
Okay. All right. How about after the letter from the city came, what actions did the landlord take then?
And I'd like to speak to that. So she filed that code complaint with the code officer. He draws it up. He snail mails it to the owner in Houston, who, when he finally did check that mailbox, texted me a photo of it. So I got it so much later than I could have if that had just been, those requests or concerns had just been emailed to me. But we, other than the rodent stuff, which is ongoing, the other items I believe were addressed the same day. Mr. Barcenas came out and redid the trim of the backyard slider.
Hey, Miss Adams, your landlord that you work for didn't get the letter until when?
He texted it to me. May I look?
Yeah.
Okay. There it is. He accidentally sent it to me and my drainage guy for some reason, so it's not in my direct text messages with him. He got it on October 30th and sent it to me at 1:35 p.m.
Right.
And I
Now-
still had things fixed same day.
What actions did you take on October 30th?
I gave Mr. Barcenas the call to please go deal with any trim issue that was happening at the slider and do the window glazing. Ms. Curry is stating that that's still not done. And if that's the case, I'd love to come fix it. I'd love a photo of where it's occurring. I'd love any guidance. I mean, I think that I have proven and will continue to prove that anything I've found out about, I have responded to timely. But I do have to know about it, and I do need, you know, specifics.
I don't believe the duty of the home falls on the tenant.
You both have responsibilities under a lease. I'll just highlight that for both of you. Each of you have your own set of responsibilities and conditions under the lease. The tenant is often responsible under the lease to take care of the entire property. I've even seen landlords put in there where you've got to repair the roof if something happens to it, through no fault of the tenant. Now, is that a good contract? I don't know. People have their own reasons to get into things, right? What is reasonable to one may not be reasonable to another. But if two people at arm's length negotiate and enter a contract, the court doesn't say whether or not you can. We only say whether or not it is illegal. So that wouldn't be illegal, right? I don't have a copy of the lease. Does anyone?
You do. I believe Ms. Curry uploaded a copy of it.
Let's take a look. First, I've got some photos from the defendant, right? So we saw the pest control response.
Okay.
All right, what is this a picture? Miss Adams, this was one that was submitted by the
If
defendant.
you can see this very thin black line between the deck and where the siding starts up, that's where can you see that foam?
Right here?
Yes.
Okay. That's where he foamed it in?
Yes. Yes.
Who took this photo?
Oliver Pest Control, the tech that was there that day doing all of this sealing up.
And what day was this done?
The day after I approved the bid. 1 second. It will probably say back in my invoicing with them. One moment. Holly. Oh, you went back. Okay.
Here's where you said they recommended the ceiling, and then
Yeah, so it was done the very next day after it was bid to me. Yeah, on November 13th, Oliver Pest Control sealed up multiple exterior gaps. Photos and evidence also noted that traps set off outside could have been a squirrel. And then they set a squirrel cage under the house. So now we're also trying to deal with squirrels. So
all right. So this is the back door, back patio. They've sealed up the space. Is this part with the siding? Is this the pier and beam?
this section, yes, back here is the pier and beam addition.
Okay. All right.
That's more of the stuff.
Gaps.
Yes.
I can see that. Yeah. So did they fill those up then?
That is filled up. It's hard to tell because it's black, but yeah, it's this black foam stuff he's putting everywhere. And even in one, he put it around this box. He even used some really thin meshed wire at one point because the gap was large enough to require that.
I have too many things open. My system is going too slow. No, that's not y'all's fault. That's what happens.
A lot of evidence.
Well, it definitely, so that's not uncommon. All right, I see. This one's a little bit clearer. All right, I can see there's a gap under the rock and the decking, and so I can see where they've put
Yes.
these blacks with spray foaming.
And there's the mesh there, yes.
All right. Wiring to keep them out. And then how about for the windows? You have any information here on the windows?
I do, yes, ma'am. So she let us know the windows weren't locking early on. And go back to that. But Fernie did go by, and they're a horizontal slide. His invoice says showed tenant how to lock windows. When we were made aware that there were additional windows giving her problems, Fernie went back. These are old windows with an additional hardware. It's like a clip you screw on to, it's a safety lock. And she was provided those for any and all. I don't think he could go into the child's room because it was napping, but he left ones for her to add on wherever needed.
All right, Ms. Curry, is that correct? Did they provide you with additional locks for the windows?
Yes,
All right, do you have a lock for all the windows now?
not all.
What windows still need a lock to be secured?
There are 2 external facing on the front of the home, but he said that it's a different part. He can't fix to the windows that slide vertically. Those are only for the windows that slide horizontally,
Do the
which
two
he
front,
made you aware of, Miss Adams.
May I ask a question? I believe at this house, it's a 1960s home. There's original single pane windows. In some of the places, at some point in time, someone came by and instead of putting in double pane, they did that thing where you just put another single pane window in front of an old one, if you know what I mean. Are these windows ones that have 2 basically different operating single pane windows?
They're the external windows out of the front of the house, which is my daughter's room, the living room, and the extended foyer.
Gotcha. So that's the window that faces the street. Is there an additional window inside the home, inside that external window, interior to it?
No.
and Ms. Curry, those 3 windows, you cannot lock them?
They don't lock properly and they don't stay open either. He said that they have I forgot the term, but there's something broken on the way that it slides. And so he has requested the parts, but he even mentioned they're old windows.
All right,
We
but
have ordered those parts.
all right, parts have been ordered to repair those windows. All right, Ms. Curry, you've been in the property a little over a month now. I can see that, right? You moved in, or you got the keys on the 13th. I understand that you weren't able to move in and actually affect usage of it for a few days. And then when you did move in, you discovered that some of the windows weren't locking. You weren't able to hook up the gas because there was an actual, a major issue with the gas line not being proper or needing to be repaired. You notify the landlord of these things, and the landlord has responded. They've come out, they have fixed the gas issue. They have sent out mediation and are working on completely remediating the pest control issue. And then we come to the glass glazing. And Ms. Adams says that she's done some. Ms. Curry, do you know if they've made any repairs to the glasses? To the glass glazing?
I don't know.
All right, Ms. Adams, what proof do you have for that?
It's an invoice from Mr. Barcenas. One moment. My apologies. And I love him, but he, English is not his first language. His invoice simply says Cannonwood, fix window, trim all around door. Dear sweet man, but that's what I have from him. And if it's not done to anyone's satisfaction, we will come out and do it, but we do need to know about that.
All right, Ms. Curry, when's the last time you made a request for a repair?
Anything was with pest control. And on November 7th, I had them come out and look at the property themselves because we had a flood after they fixed the washer.
Who's
Which-
Ms. Curry, who's they?
Miss Adams came to the property.
The landlords came out and inspected the property
Yes,
on November 7th.
yes, ma'am.
Okay. What happened when they came out on November 7th?
They were able to see that the contamination still remains in the attic after that they had their sanitation. They've also requested that I give them full detail about what sanitation and remediation mean. And so they claim that Oliver Pest Control doesn't know what that means, but I have 2 different contractors that seem to understand that. And so I don't believe that that's being fully met with the vendors that they're using.
Ms. Curry, here's my question, because I absolutely empathize with the situation, right? You're frustrated. But when I'm reviewing the law, the landlord seems to be complying in that they are responding within a timely fashion and attempting to ameliorate and are working in good faith to fix it. In that regard, where is the violation giving rise for your lawsuit?
I believe that they're acting in bad faith because they're fabricating advice and evidence and they're making false safety guarantees. That spraying bleach on insulation and not removing feces has made it to where the air is perfectly clean. Also, there's an unattended bait above my daughter's bedroom, which goes against what you're supposed to do as a licensed technician.
Ms. Curry, I don't have any proof of that. And in fact, the letter,
do,
Ms. Curry, I read that document and it says best practice. It doesn't say it's illegal or completely improper. It's just not what they would do. Many people may go about fixing or remediating something in a different way. It is not illegal or improper for the landlord to choose a lesser, cheaper method first. And if that fails, then to move up in specie. With what
They've
I've got,
denied moving up.
Ms. Curry, I don't see that. And also, they still have 4 days to comply with the city ordinance. And
I
per
have
what
emails where they've denied because of cost.
Ms. Curry, they're allowed to. They are still taking action to fix it. They have, and you've acknowledged that they have sent out maintenance. They have continued to send out their choice of vendor, Oliver, and they absolutely get a choice of repair. As the tenant, your rights to seek a repair are a little bit less. You have to let the landlord attempt to fix it first. And it seems that they are attempting to fix it. It is true that pest control is not a one and done, as highlighted. And I see these cases a lot. It may be an ongoing thing, but if the landlord is working in good faith with you to get it repaired, that is all that is required. The option, which I hear the landlord gave you, is that if you are uncomfortable for good reasons, you may not want your child around that situation, understandable, but they do not have to find you an immediate solution if they are working in good faith to fix it. The other solution would be for you to terminate the lease and leave, and that's been offered. If they have made good faith efforts to fix it and are still continuing to work on it, and nothing I've seen doesn't prove that they are doing that, I don't find that they are in violation of the repair and remedy statute in Texas, at least not at this stage. Right? I know that's disappointing. I understand, again, the frustrations are real. That is no doubt about it, right? But the statute provides some specific things. It provides repair and remedy, and then there is a timeline for specific types of things, right? Sometimes it's 24 hours. It's an immediate duty if it's flooding or sanitation. They get 3 days for certain things. They get 7 days, and then it's if they are responding in good faith. Ms. Curry, the last thing I'll say is this. Today, I don't find that you're showing the burden of proof that the landlord is failing in their duty to repair or remedy, albeit time may change things. So it may be, if you stay in the unit, I could say, keep track of your records. Ms. Adams will keep track of what they're doing. You can revisit the issue if a repair is not affected in the future. And I can't give you any information about how long that would take because that gets into legal advice. I'll just inform both parties that my ruling today doesn't preclude this issue coming back up, right?
I guess I don't understand how the remediation is being touched on.
They are trying to stop rodents from getting into the building. They are trying to seal
There's
it.
already contamination of the rodents that they're not willing to remove.
Ms. Adams, are you not willing to, when their guys go out, are they not picking up the droppings and cleaning it out?
We have absolutely sent Mr. Renteria once to do that in the kitchen and the attic. And
I have videos where it shows the day after he did that, it's still there, and you saw it with your own eyes here in the home.
As the judge, I'll say, Ms. Curry, it seems like there is still people, insects and rodents are still getting in. So I'm not surprised that you keep finding feces. That doesn't mean they're not cleaning what was there. It may be reoccurring.
I have videos that show the day after, hours after they had done their cleaning, where there's feces. And Ms. Adams has told me that there's no active infestation, that she believes that I'm just hearing things.
I don't believe that. Mr. Adams has said that, and Ms. Curry, I don't disbelieve what you're saying. I know you're not telling a lie because you've got 3 independent inspectors, 4 if you count the city, who agree with you.
But they're still not cleaning.
Ms. Curry, I don't find that they are not trying to remediate or repair as required by the statute. I'm afraid that there's no order for repair or remediation from the court today. Parties can definitely still communicate with each other and see if some other resolution can be worked out. And Ms. Curry?
I've had harassment from her end, so I can't communicate with her. In retaliation, unannounced visitors in my home without giving me notice. They won't tell me who they are, but I can't afford to move. So I'm in a situation with somebody who's making it seem like I'm making things up.
I don't believe you're making anything up, Ms. Curry.
Rat feces to be removed. They have told me they sprayed them with bleach. That suffice. It doesn't. And 3 other vendors have said that it doesn't. So if we had a way to get the feces gone, then I would feel better about this, but it's still above me. It's still in my kitchen. It's under the dishwasher. It's under the oven. Your vendors have not done that. They threw bleach water down on the kitchen floor and then mopped it up.
All right, thank you all very much for your time today. The ruling of the court is that there will be no repair remedy issued. Ms. Curry, please do continue to pursue your rights. And Ms. Adams, please do your very best to make sure that you're not renting something out with broken windows and broken locks and no gas and a dirty, dirty, dirty kitchen. I mean, I saw those photos.
Can I speak to the no gas?
I don't need you to speak to it. I need y'all to not rent something like that again. That seems like a good solution going.
Yeah, that seems fair.
All right, all parties are excused. Thank y'all. Thank you.
Court calls case of the people versus Milton Ray.
Arbor, on behalf of Mr. Ray, who's approaching the podium and will be standing to my right. It's here. Mr. Ray, once you approach the podium, please state your name for the judge. Milton Ray. Thank you, Your Honor. One more time, a little louder so the record. Milton Ray. Thank you, Judge. Thank you, sir. Your Honor, today's the date and time set for probable cause conference. May we approach?
Yeah.
Thank you, Judge. Thank you.
Record should reflect data bench conference. Go ahead.
Thank you, Judge. So at this time, we are here for PCC and bond violation. At this time, Mr. Ray is going to admit the violation for positive tests.
All right. Is that correct, sir?
Yeah.
Okay, and you understand you could have a hearing on it?
A hearing?
You don't want a hearing?
Well, it means you could have, it means you could contest it if you wanted to, but we're just going to admit the violation.
Oh, okay.
Is that what you want to do? Do you understand that?
Yeah. That's what you want to do? Okay, I'll accept the admission to the violation. Okay, what are we going to do with the case? And then,
Your Honor,
how long has he been in?
When did you get in? About a week?
Last Saturday.
So since since last Saturday, so about a week.
This past Saturday?
Yeah, so just been one Saturday. Yes, just this past Saturday.
Go ahead. What's your argument?
Your Honor, we would ask for a bond that Mr. Ray be released back on bond. We have had a discussion and we have had discussed going forward that he needs to stay clean and have no more positive tests. He's a Marine Corps veteran and he has he receives Social Security and does odd jobs. I would also like to note that the complaining witness in this matter is currently also in Washtenaw County Jail for 2 DV third felonies, at least one of which he is the victim on. And so we are asking that he be released on bond. One of his tests was positive for drinking, so that we would accept either a sober link or a drinking tether to keep him in line on that. Nothing further.
Otherwise, what does he want to do with the case?
Well, if he stays in, we'd like to be set for exam. If he is released, we'd like to be adjourned.
Well, I'm going to sentence him on the violation to 15 days, credit 5.
Okay.
So
we'd like to be set for exam then.
Okay, that is his sentence on the violation. And then discovery is complete.
Yes, Judge. To my knowledge.
People, are there witnesses available to second?
We'll do our best, Your Honor.
Preliminary examination in person, December 2nd, 2025, 9 a.m. Before Judge Barr. At this point, Bond will continue. Thank you.
Keep your head up.
Court calls case of the people versus Deidre Woods.
Oh, she's on the, okay. Let's state your name.
Deidre Woods.
Thank you, ma'am.
You're welcome.
Things are just a mystery for you, aren't they, Miss Hacker?
Go home and start over. Judge, we are asking for an adjournment today. We are still in negotiations with the people. I'd also like to address bond, please.
Probable cause conference will be adjourned December 4th, 2025, 9 a.m. on both matters. As to bond.
As to bond, Your Honor, we're asking for a PR bond in this matter. Ms. Woods is currently dealing with a matter in circuit court. In that matter, she posted bond and she had a hold out of Wayne County. So Wayne County picked her up. And when she resolved her matter in Wayne County, they wanted to release her on a tether. But then these warrants were authorized. These warrants are just a little older than the original case, so it's not as if there was a new case that she picked up while she was in custody. So she is looking to see if we could get a PR bond on this matter, as she already has a cash bond that she's posted in one of the matters in this district, and I mean in Washtenaw
What kind
County.
of case is that?
The other case is a. Give me 1 second, Your Honor. I apologize. Malicious destruction of personal property, Judge.
Any response from the people?
Your Honor, the home invasion file is older. It's about a year and a half old from 2024. However, the case brought in the other file charge, the financial transaction device, is just an offense date from this summer. She would have been out on bond at the time that offense was committed. And with the two open cases, I think that some form of drug testing or other physical monitoring is appropriate, not opposed to the PR bond. I just think appropriate conditions are necessary.
Does she have, is on her release on the other case, is there a drug testing component to that?
I can check, Your Honor. I do not believe so.
Supposed to be a center that I'm released to, a center with not, of course, GPS monitoring.
And Judge, you mean
The
the
PR bond.
Washtenaw County?
Pardon? Yeah, the one in Washington.
I don't think so, and she hasn't been out to be able to.
So I guess there's that. And then the other thing is, if she's released on our cases in a way, is she then to go to Wayne County to be put on a tether?
That is correct. That's my understanding, Judge.
All right. I'm going to grant the modification in both cases. I'm going to give her a $10,000 personal recognizance. In each case, she is also in our cases to be placed upon a GPS tether prior to release.
Okay.
All right. I am also going to order that she report to community corrections for 2 times per week drug testing. All right. Anything further?
No, did we get a date, Your Honor?
I wrote one. So I say yes. Did you not get a date?
Your Honor, for the record, I didn't hear it.
Why do you cover? Why do you really, man? Really? You could have just left it alone. You did not need to be part of that. And I don't know why you're covering for acting. We had her going that I said it. She didn't hear it.
Thank you, Trevor. Thank you.
I don't know what's going on here. Mr. Allen, did I give a date? Thank you. See, somebody was listening. Thank you. That is the date. I wrote it. It was there before I started adjusting your bonds. God bless you.
Thank you, Your Honor.
It's good to see council's listening.
So Deidre, your next date is gonna be on the 4th. I'll come and see you and give you all the information, okay?
Yes.
And the rest of us knew that before she did.
Simpson.
Thank you. Court does call the cases. People versus Jesse Ivey.
Ashley Phelps for the people and all 6 matters.
All 6 cases.
Public defender, really, Your Honor, on behalf of Mr. Jesse Ivey in all 6 matters as well. Mr. Ivy, state your name for the record, please.
Yes, thank you.
Judge, we're asking for an adjournment in this matter. We're hoping to get a global resolution, and I'd also like to address bond.
But the global resolution includes more than these 6 cases?
Yes, Judge. I do believe there is a district court case as well.
Okay.
Right now.
Yeah.
8 open, including these 6.
Yes, sir.
All right. So how much time would you need to try to get all that worked out? That was a question.
Yes. Yeah,
Okay.
yeah. I guess we can do
I have the 11th or the 18th?
let's do the 18th.
18th. Probable cause conference in these cases will be adjourned to December 18th, 2025, 9 a.m. Yes, as to bond.
As to bond, Your Honor, we are asking, I know that we do have low bonds on these cases. I think 3 of them, so what?
You want me to let him out on all these retail frauds just in time for the holidays?
Well,
No, go ahead.
Judge.
Go ahead, make your argument.
Yes. Mr. Ivey he was in custody on 3 matters. He received a PR bond on those matters and he went over to Wayne County. And while he was in Wayne County, it's like deja vu. While he was in Wayne County, 3 more matters were authorized. So he completed,
Were they retail frauds?
yes, Your Honor.
Okay, all right. So that's 9. Go ahead.
3 more matters here were authorized. So that is why he's back here in Washtenaw. He was given a tether and a cash bond that was posted in Wayne County. And I know that the bond is not significant in these, but his family does not have the money to assist him with posting the bond. He reports that he is a father of 3 children. He has sole custody of his 5-year-old. So his elderly grandmother is actually helping him keep his 5-year-old right now while he's in custody. He reports that he is currently employed. He's hopeful that he'll be able to maintain his employment once he is released. He does have a good relationship with them.
He's employed?
Yes, Judge. He was prior to being arrested.
Okay, go ahead.
He was out of custody initially, and he was coming to his court dates. So the court should be able to see that his other hearings, he did appear. And then he was put in custody because he has a few cases that he's trying to keep up with, and went to the wrong courthouse in Wayne County. Once they realized the issue, they let him go, put him on a tether, but then by then, our new cases were authorized, and that's how he made his way over here.
Oh, you done? Okay.
Okay.
I can't wait for this. Response.
So, Your Honor, in 2021, the defendant was convicted of carrying a concealed weapon and sentenced to 1 to 5 years in the Department of Corrections. I can't tell for sure if he was on parole at the time of these, but it very well may have been, or very recently discharged from parole. I need that. In 2015, sorry, 2011, he was convicted of unarmed robbery, and in 2011, he also had another case for unarmed robbery where it looks like he got FIDA along with the 3rd-degree fleeing and eluding, and in 2006, he was, as a juvenile, adjudicated for a felony firearm case related to another robbery. Your Honor, I am asking the court to continue the bond as set, as most of these cases originate from the same location at Macy's, and they're high-degree retail frauds.
Anything else?
And Judge, we appreciate the information about Mr. Ivey's past, but he's been off of parole. I want to say that he's served his time.
Appreciate it.
It's
Okay, no, go ahead. I've never heard that before. but
it's
go
been
ahead.
offered, so we
Yeah, it was kind of flippant, but go ahead.
so Judge,
No, but I was listening.
as it pertains to these matters, Your Honor, he was on bond. He was coming to court as required in these cases. And the only reason he's got this new bond is because there were new cases that were authorized after the fact. So he's been compliant with his bond when he was out, but for his mistake in Wayne County, which was quickly resolved, he would have been able to come in and turn himself in and do an out of custody warrant recall on these cases once they were authorized. I think that Wayne County is going to put the tether on him. I don't think he's opposed to a tether if the court feels that that is necessary. These are nonviolent cases. I don't think that he poses a risk. And yes, it is the holidays, Judge.
So, but he has a violent past and a theft past. And as counsel indicates, he might have been on parole or probation when some of these offenses
No, he
occurred.
reports that he was off, Judge,
Off of.
parole for 2 years prior to these
All right.
cases.
So what I'm gonna do in this case, though, is that I'm not gonna change his bond. I'm gonna deny the request for a bond reduction. Let's see if we get all of these wrapped up or how, whatever's gonna happen with them prior to his release.
Okay.
So bond is denied. The bond. Motion for bond reduction.
Thank you, Your Honor.
Court does call the cases of the people versus Ryan Phelps.
Government vote for the people.
Ryan Phelps. Thank you.
Your Honor, I believe we have a resolution of these matters. I am. They're going to be guilty, please.
We get those to my staff before I go ahead.
Here, you need to sign these.
Mr. Gay has been in touch with me throughout the week, and I think on 3 different occasions, he has been in touch with me in order to reach today's resolution. I apologize, we weren't able.
And I have gone over his rights with Mr. Phelps. He informs me he's not on probation or parole. And
I have a.
I don't know if we need a plea form in the 15th district matter, Your Honor.
Well,
He's
this
pleading-
one is for the 15th district court.
Yeah, he's pleading guilty to count 2, which is the retail fraud on the complaint, and there's.
I need a plea form because that's how they go through.
Okay, yeah, I did fill out a plea form. I just didn't know if the court needed it. That's for the 14B matter.
In the case ending in 1285, we have a plea form now that indicates that the defendant is going to be pleading guilty to counts 4 and 5. Count 4, malicious destruction, 200 to 1,000, the 1-year offense, and count 5, an assault and battery, 93-day offense. Upon a successful plea to that, charges counts 1, 2, and 3 would be dismissed. Defendant is also agreeing to pay restitution for all tires.
Yes, Your Honor, it's a tire slashing case.
He's going to pay restitution for all the tires. There is no sentencing agreement. That's court's full understanding in that case. In the other case, it's the court's understanding that he's going to be pleading guilty to the stated count 2 of retail fraud in the 3rd degree, 93-day offense. Upon a successful plea to that charge, count 1 would be dismissed. That's the court's full understanding of the agreements in these cases.
That's correct, Judge.
Just having sworn.
Raise your right.
Do you solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name.
Ryan Phelps. Sir, it is this court's understanding you're going to be pleading guilty to 3 misdemeanor charges. Is that your understanding? Yes, Your Honor. In the case ending in 1285, the Ypsilanti Township matters, you're going to be pleading guilty to an added count 4 of malicious destruction of property, 200 to 1,000. That's a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. The fine could be increased to 3 times the value of the property, which is otherwise destroyed or injured. If that's greater than $2,000, that becomes the maximum fine. You understand that? Yes, Your Honor. And also in that case, you'll be pleading guilty to the charge of assault and battery. That's a misdemeanor punishable by up to 93 days, $500 fine plus court costs. You understand that, sir? Sure. In the other matter, the City of Ann Arbor matter, you'll be pleading guilty to the stated count 2 of retail fraud in the 3rd degree. That is indicated as a misdemeanor punishable by up to 93 days of jail, $500 fine plus court costs. The fine could be increased to 3 times the value of the property taken. If that's greater than $500, that would become the maximum fine. You understand that? Yes, Your Honor. Sir, I do have to advise you that in the 14B or Ypsilanti Township matters, while I'm taking your plea, I would not be your sentencing judge. The sentencing judge waiver is not signed. Did you go over that with him?
Yes, Your Honor. I believe he signed, I had him sign both forms.
You understand that I would not, while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court. Yes, Your Honor. In the other matter, likewise, while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Valvo in the 15th District Court. You understand that, sir? Yes, Your Honor. All right. Still wish to plead guilty? Yes, Your Honor. To the charge of malicious destruction of property, 200 to 1,000, how do you plead? Guilty. To the charge of assault and battery, how do you plead? Guilty. To the charge of retail fraud in the 3rd degree, how do you plead? Guilty. You understand that by pleading guilty, you will not have a trial of any kind in this matter? Yes, Your Honor. You signed an advice of rights form, is that correct? Yes, Your Honor. Any question regarding any of those rights? No, Your Honor. Please look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as other rights on that form. Yes, Your Honor. You understand you're giving up your right to appeal of right? Yes, Your Honor. Are you on probation or parole? No, sir. Has anybody promised you anything other than what's been stated here today on the record to get you to plead? No, sir. Anybody threaten you or coerce you? No, sir. You're doing this voluntarily and of your own free will? Yes, sir. And also because you believe that you are indeed guilty of these offenses? Yes, sir. Starting again with the Ypsilanti Township matter. Sir, on the date of August 28, 2025, at the location of 6261 Lake Drive in Ypsilanti Township, Washtenaw County, State of Michigan, what did you do on that date involving involving a Samuel Hasley that makes you think that you're guilty, Samuel or Austin Hasley, that makes you think that you're guilty of assault and battery? And what did you do regarding the property of Austin Hasley that makes you think that you're guilty?
As of right now, I can't quite remember, Your Honor.
Your Honor, I'd ask the court to adjourn this matter to Tuesday. So we
I'm
can.
not doing Tuesday. I will adjourn the matter to December 4th, 2025, 9 a.m. Thank you. Bond continued. Court calls the case, People versus Raphael Starks.
Hannah, on behalf of Mr.
Oh.
Starks. I was here.
You decided to show up today.
You know,
Yeah. What do you mean he knows?
you know, I was here at like late early.
Late early. What'd you say?
She told me the same thing.
Say she told you the same thing? You do believe it?
A little bit.
I don't.
I trust you.
No. Yeah.
Your Honor, Mr.
That's your problem. No, not
He
kidding.
does. I got him. Sorry. Well, excuse me. We're gonna waive.
He's waiving his right to a preliminary exam.
And Your Honor, when appropriate, I would like to address bond.
All right, sir, you're waiving your right to a preliminary examination?
Yes, sir.
You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed?
Yes, sir.
You understand that you'll not have that hearing, you'll proceed to circuit court for further resolution?
Yes, sir.
People also waive their right?
Yes, sir.
Preliminary examination having been waived, defendants bound over to circuit court on counts 1 and 2 with counts 3, 5 following.
Your Honor, we would waive the formal reading of the information. We would stand mute as to the charges.
Defendant having waived formal reading, pending court will enter a not guilty plea as to all 5 counts. Pretrial in this matter will be set for
December 1st at 1:30, Judge Hamud.
December 1st, 2025, 1:30 before Judge Hamud.
And Your Honor, as to bond, my client, he understands the seriousness of this nature. He is asking for if you could amend the bond by lowering it to maybe a 5,000, 10%. He has been taking care of the bonds, the holds that he has. He's gotten 2 PR bonds, I think. We know the Oakland County matter. We're trying to get him arraigned on that as well.
What are those other charges?
The OWI is out of Oakland. He has an OWI hold out of Oakland. But it is from 2021, Your Honor.
Okay.
And so he has a hold there. So he's taking care of the driving while license suspended, which just leaves him with the OWI. And we are working to see if we can get him arraigned on that as well. So we're asking for a low bond in this case, so he has the opportunity to bond out. He is the sole provider for his household, which includes his wife, mother, and daughter. His job, as he knows it, is still waiting for him. He just needs to get out to get back to work. He is willing to go on GPS tether. Any transportation will be handled either between his mom or his wife, so he won't be getting in a vehicle anytime soon. And Your Honor, we are hoping to resolve this well short of trial. He's just asking for the opportunity to be released.
Response.
People would object. Obviously, this OWI out of Troy has been pending for quite some time, and he wasn't resolving that. He was pulled over for a traffic violation in this matter. He had a suspended driver's license. The officer advised that he needed to be taken into custody to look into the hold for that Troy OWI. He instead put the car in drive, drove off, ran over the officer's foot, injured the officer. And to his credit, he did later turn himself in at Eastern Michigan Police Department. But in light of the fact that he has been, or at least that he has not resolved that case for several years, he ran over officers. In this case, to avoid that, people are concerned that he would not comply with the conditions of bond. We've asked the court to deny the motion.
Your Honor, in talking to my client about what happened that day, when the officer reapproached, he had his hand on his gun, and my client, he freaked out. He didn't even realize the officer had been injured. As soon as he got home, he thought about what he did and he turned himself in. He didn't know about the injury. He is just asking if he could be, and again, I think GPS tether would accommodate, keep the public safe in this particular case and assure that he is appearing for court.
When he ran over the officer's foot, he obviously escaped the scene at that point.
That's correct.
Yes, he went home and probably within a couple hours, he turned himself right back. He turned himself in.
What I'm going to do in this matter is what I will do is I will lower the defendant's bond. I'll give him the 10% provision on the bond of 20,000. I will not lower it where you want, but I'll give a 10% provision. But defendant must be released on I guess what I'm concerned about is whether or not there's a substance abuse or alcohol issue.
None, Your Honor. None of his charges. Oh, the OWI.
Why? That he never dealt with.
It has to be dealt with, no. You gotta address it. 'cause it-
All right, so I'll reduce that, but defendant would be, so I'll reduce it to a 10%, but defendant must be put on a GPS tracking location tether prior to it.
Thank you, Your Honor.
Court does call the case People versus Christopher Walker.
This is Public Defender Zach Vinue on behalf of Mr. Walker, who is present and approaching. Can you please state your name for the record?
Oh, Christopher Walker, Christopher Lawrence Walker.
Thank you.
Your Honor, we would request an adjournment. We are waiting on some discovery. We just got the police report yesterday. I believe we're still waiting on the media discovery, and then I would ask to address bond when appropriate.
Probable cause conference will be adjourned to December 4th, 2025, 9 a.m. Yes, as to bond.
Your Honor, so Mr. Walker has been in custody for 8 days now. He is fearful of losing his jobs. He has 2 jobs, Your Honor. He works at Molly's Cupcakes and Jolly Pumpkin. Are those both the downtown Ann Arbor
Yes, sir.
locations? Yes, sir. He is currently.
Jolly Pumpkin. Go ahead.
I believe there's one in like East Lansing as well, Your Honor. But so he's currently
that.
What'd you say? Your Honor?
East Lansing?
I don't know where that is either, Your Honor. I apologize.
Why would you even bring that? There's multiples?
Yeah.
Thank you for sharing. I don't know why. All right, anyway.
So, Your Honor, he's
Not mean for
currently.
this to go there, but
Yeah.
go ahead.
Your Honor, he is currently at risk of losing both of those jobs and being unable to support his children. He has 5 children, Your Honor, whom he supports financially. He is not a flight risk. He's lived in Washtenaw County on and off for the last 15 years, Your Honor. He's originally from Taylor. So we would be asking for home confinement with a GPS tether and the ability to travel to and from work. I can provide all the
Why
addresses.
is he in custody?
Your Honor, the charges are an R&O and then a misdemeanor assault and battery. Yeah.
I know what the charges are. Is anything else holding him?
No, Your Honor.
Response?
And people would object. In this case, police were looking for him because there was a report that he had assaulted a romantic partner, was kicking the windows at her home trying to get in. While he was walking down the street, it is alleged that he walked up to a gentleman and just punched him for no reason. That's the gentleman who called the police. That victim is the victim of the assault and battery. In this case, he maintained visual of the defendant as he went to the speedway. The police officers arrived. He pointed them out. The defendant then resisted being taken into custody. He fought with the officers. He was verbally abusive. And when the victim of the assault and battery was brought to identify him, he repeatedly said, "That's why you got punched in your shit." So this is a person who people have concerns about safety of the community, does have this criminal history, buildings 1,000 to 20,000, domestic violence, arrests, an attempt, assault with intent to do great bodily harm, or by strangulation.
Motion for bond reduction. I don't need any more. Motion for bond reduction denied. Bond will continue.
Understood, Your Honor.
Thank you. Court calls the case of the people versus Devon. Is it Galliard?
Ready, Your Honor. And good afternoon to you and your staff, Your Honor. Attorney Maxwell Dubin, P number 86012 on behalf of Mr. Galliard.
Ma'am or sir, where's your client?
My client is currently in Georgia. I'm ready to address everything on the record here today, Your Honor.
Well, is he here?
He's
There
not
he
here
is,
in
right
person.
there.
Yeah, he's
I
on
see.
Zoom, Your Honor.
Sir, state your name.
Devon Galliard.
All right, why don't we address that? Because
If I may, Your Honor. So evident from the information that defense has received and I've received, my client does and currently still does live in Texas, Your Honor. Again, he's never been in this situation before. That being said, he is monitored on a tether. I believe he, for lack of a better term, a misunderstanding where he was under the impression that since he's returning to Texas and is going to eventually move closer to Michigan, being Georgia, that he was able to go there while being monitored. Again, I would just point out this is not an
But
excuse,
counsel,
reason.
no. He never went to Texas. He said, I watched the video when I got this, and you guys he indicated he was going to Texas. There was nothing about Georgia, North Carolina, or any other thing. Nothing.
And I do understand that, Your Honor. My client's not sitting here trying to deceive you or the court, and he was very upfront and honest with the tether people when they asked, and he did talk to them with the tether company. He was not trying to hide anything. And I can completely understand the court's frustration with that. And I just would like to say that is not my client's intent. He does not have a history of skipping court, and the only reason I had him appear and as stated in court prior, if you do remember, but I know you deal with a lot of cases, so I wouldn't be surprised if you didn't. He was even willing to buy plane tickets to fly back and forth through the onset of this case. So I would just like this court to know, Your Honor, that my client is not trying to avoid anything and avoid you or the court or this case in any way, shape, or form, Your Honor, or disobey you for that matter.
Ms. Zenda.
Your Honor, I have concerns given that, one, he was not permitted to appear on Zoom today. That was revoked given this report. I also have concerns given that the representations that were made was that he was going to be living in Texas. He never goes to Texas, starts residing somewhere else, and he doesn't come back for this hearing that he was supposed to be in person for today. He's facing very serious charges. I have concerns that he's just out and about across the country. I originally wasn't comfortable with him even going to Texas, and I'm even more uncomfortable with the arrangement.
So, and I have a problem, counsel, when, as indicated in the community corrections report, he told them that he was permitted to travel to Texas to get his things and that he could stay in Georgia. That was never talked about, not at all. And outside of the fact that even if it was, he's not just in Texas, he's in South Carolina, North Carolina. He's all over the southern eastern seaboard, with the exception of Florida. At least we don't have him there. And he's just going about his own, doing whatever he wants to do. And Ms. Senda's right. Once we get this, his permission to appear via Zoom was revoked. He needed to be here in person. He is not here.
If I can speak for myself, I'm sorry, Your Honor. I was just, the reason why I didn't because I did my household goods virtually, and they was gonna send my stuff here. So I wanted to save money and stay here in Georgia.
You don't have the permission of the court to be in Georgia.
That's my apologies. I wasn't tracking that. I was trying to make it easier so I can be closer here to, if I need to go to court, I could be here with my mother and I could just go from here to Michigan. Because I did, when you said that, as long as I'm on this tether, I can go anywhere I need to go. As long as I didn't go anywhere near Texas. No, you did say that. You did say that.
No, Mr. Galliard, I'm gonna, and Your Honor, if I may, I don't mean to interrupt you. But
go ahead.
I've talked with my client. My client is taking full responsibility. I have talked to him about this today. He completely understands the frustration with the court, and that just because you're given permission to travel does not mean you can go wherever you want. He is understanding of that, Your Honor. I assure you that. And
but he's representing that I told him something I didn't say. He's representing that to our community corrections. I'm not having it. When I let people travel, I let people go where they want to go. The circumstances were given to this court. He said he lives in Texas. He wanted to go to Texas. I was going to allow him to reside in Texas. Come to find out, he never went to Texas. He's somewhere else, a few thousand miles from Texas, and just is there and trying to give me some excuse. I'm not having it. He needs to get himself back to the state of Michigan. If he doesn't want to get himself back to the state of Michigan, we will come and get him. A bench warrant's going to issue for the defendant's failure to appear. No bond. So you better get here before we get to you. I'm done.
And Your Honor, my client can turn himself in at any point. We can readdress this when he comes back.
We
'cause
will be
he will be
more
back
than
very
happy
shortly.
to take him.
Okay,
Thank
Your Honor.
you.
I will speak with my client and arrange his return, Your Honor.
Court does call the case. People versus Dwight Miller.
People.
Good afternoon, Your Honor. Rob J. Kilwald calling outside of Judge Slay's courtroom. Good afternoon, Your Honor. Dwight, would you state your name for the record?
I'm American State National. I'm appearing sui juris. You is not my attorney. That's not working for me. We got a whole issue. All my constitutional rights have been violated. I want it on the record. I was arrested by a lie. I want it on the
Okay,
record.
first of all, I'm
On
going to
the record.
stop this. I directed this defendant to be in this courthouse in
I got a
person.
bad back, sir.
And he is
I
not
got-
here in person.
Sir, I got
I
a
am
bad
not going to
back.
sit here
I
and
got a
listen to
medical
him
issue.
ramble on and on about everything.
really?
I don't
So you
mind
gonna
hearing
violate
from
my
people, but I
constitutional
tell
rights?
you, if you're
You
going to
gonna
say
violate
it
my
all, you're going to
constitutional
say it to my face. Bench
You gonna
warrant will
violate
issue
my
for defendant's
constitutional
failure
rights?
to appear. No
I
bond.
am here.
We'll get
I
him
can't-
here.
I got a
Thank
medical
you.
issue.
You
So
can
you gonna
mute
violate
him.
my
Thank you, Mr. Kilowog.
Okay, Judge. Thank you. Judge, if I may say, he does have some medical issues. That being said, all I wanted to do was set it for exam.
Well, when he gets here and graces our doorstep, I'll be more than happy to set it.
All right, I'll bring my constitutional book. Thank you, Your Honor. Thank you.
All right, thank you, Mr. Kilowog. Court does call the case. People versus Gary Coward.
Good afternoon, Your Honor. Hey, Simpson, I'm coming to see you, bro. You violated my constitutional rights. I am coming to see you, bro.
Hey, I hope you are not making a threat against me, because that's going to cause you a whole bunch of other problems. Get that number. Yeah, I bet you it did log out. Get that number. It will have the full number. We'll go find him. Get the detective bureau on that, please. All right, let's go. You don't want to come up here now, do you? I know. He's just standing there like, man, I just, oh, my name, I'm just up
Do you
here.
want me to contact Detective Bureau?
Pardon?
Do you want me to reach out to the DB?
I think he ends.
Okay.
Your name, sir?
Gary Coward.
And who's representing Mr. Coward? Mr. Burgess?
I am. Sorry, Your Honor. Good morning. Good afternoon. May it please the Honorable Court, David Burgess on behalf of Gary Coward. I'm appearing via Zoom, Judge, because it seems a little scary in your courtroom today. So.
Wow. I'm calm.
My client is present, Your Honor. He's raising no constitutional issues, and he is a citizen of the United States.
Thank you.
I'm done, Your Honor. Sorry.
No, you're not. You are just getting started. What are we
Good point.
doing on this case?
Judge, we're still trying to, Mr. Bannis and I were still trying to resolve the matter at the district court level. So I'm still discussing it with him. We're just asking for a couple weeks adjournment of the PCC.
Will the 11th work for you? I think you're here anyway on the 11th. I think
I think so.
For you.
Yes, Your Honor.
All right. Will that work for you?
Yes, sir. Can I appear at Zoom, please?
Pardon?
Can I appear at Zoom at all?
That hasn't worked out for people today. No.
He's messing with you.
If you submit talk to your attorney, there's paperwork that needs to be submitted before that can be approved.
Okay, thank you.
Okay.
Thank you, Your Honor.
December 11th, 2025, 9 a.m.
All right, thank you.
Bond will continue. Thank you, Mr. Coward. Appreciate your patience, sir.